number 45, Roman Catholic Diocese versus Vullo. Counsel.
Chief Judge Wilson, and may it please the court, Noel Francisco for the appellants. If I could reserve 3 minutes for rebuttal.
Yes, sir.
The mandate has exemptions for religious and non-religious employers, but not for religious employers like the Teresian House nursing home run by the Carmelite nuns or the others in this diverse group of plaintiffs. Under the Supreme Court's decisions in Fulton and Tandon, the state has to justify that choice. Its asserted interest is in providing abortion access to women, yet it excludes many women from that interest. That means the state has to explain under strict scrutiny why it can't exclude a few more. This case, therefore, presents two issues under the Supreme Court's recent decisions. First, is this law generally applicable? That is, does it apply across the board, given its exemptions for religious and non-religious employers? And secondly, does the law give the state the discretion to determine who is, on a case-by-case basis, a religious employer?
Well, does it matter in this case that the state wasn't making that decision, that in fact people were, or organizations could self-certify, and it wasn't a situation where the government or the state was saying, I'm going to use my discretion and allow you or not allow you?
Well, two responses to that, Your Honor. First, it doesn't actually matter whether they exercise the discretion. What matters is that on the face of the law, they have it. That's exactly what the Supreme Court held in the Fulton case, where the city of Philadelphia had never once exercised its discretion. But put that entirely to the side. The state's just wrong. If you look at the DFS guidance that implements the religious employer exemption, the exact same exemption in the context of the contraceptive mandate, here is what the state says, and I'm going to quote from it. It says that this is a quote-unquote narrow exemption. It says, and this is critical to your question, Your Honor, that the decision makers, quote, may not rely solely on a self-attestation from the employer, end quote, but then goes on to say that instead the decision maker has to demand and analyze proof of, again, I'm quoting, articles of incorporation, bylaws, charters, mission statements, brochures, nonprofit determination letters in order to make this assessment. And then finally, to make the rubble bounce, the state makes clear that the DFS, the Department of Financial Services, will, quote, take action against an insurer for any failure to adhere to all statutory and regulatory requirements in applying the mandate. So I think that they're clearly wrong.
Sorry, is there any limitation on what you're calling that discretion? Are there any boundaries?
Well, Your Honor, there are.
Does that matter?
I can't really say that there are no boundaries, but I also don't think that the boundaries matter here. The language of the regulation does have various provisions in it, but those are extraordinarily discretionary. Take, for example, the requirement that you serve people of the same religious tenets, or frankly, that you employ people of the same religious tenets, or have a purpose that is the inculcation of religious beliefs. How on earth do you determine whether the employer, its employees, and the people that it serves have the same religious tenets?
Well, let me actually ask you that question. How would you construct a statute that, let's back up a little bit. Mm-hmm. There are some employers who are non-religious. Fair?
Yes.
And there are some that are. How would you construct a statute that doesn't have discretion in it and makes that determination?
Your Honor, I would do it just as the federal government has done it with respect to the contraceptive mandate, which is essentially the same definition that DFS initially proposed before adopting the regulation that they've adopted. Remember, this litigation kind of parallels the federal contraceptive mandate litigation. Initially, the federal government proposed the exact same definition that New York State has adopted here. But in the face of intense criticism, the federal government withdrew that and instead adopted a definition that basically said if you're a nonprofit religious organization and you say that you have the objection to providing these services, you fall within the exemption. That's also what DFS initially proposed, and that is something that would be very—
self-identification, self-declaration, no one confirms it. Is that what
Well,
you're
Your
saying?
Honor, in a sense, it's similar to the free exercise clause analysis generally, where there is a threshold question, do you sincerely hold those religious beliefs? It's a relatively low threshold, but yes, it would largely be that.
It's a self-declaration. You identify yourself as such.
You identify yourself as a nonprofit religious organization that has an objection to the services provided. Yes, Your Honor, and keep in mind, The cost of providing this type of coverage is virtually nothing.
Why isn't profit and nonprofit cut the wrong way?
Well, Your Honor, I mean, I'm representing nonprofits.
No, I understand. It's a definitional matter. I mean, why is that an appropriate definition?
Your Honor, look, the actual definitions that the federal government used and DFS proposed didn't actually have that distinction. It also extended to for-profits, and I would have no problem with that. I was simply answering the question, what definition would satisfy my clients? But to follow up on the issue of self-certification, the state, in its brief in opposition in the United States Supreme Court, page 7, footnote 5, made clear that the cost of providing an insurance-only policy is between 11 and 13 cents per month per person, less than $3 a year. So I don't think there's any risk that you're going to have a flood of for-profit organizations or others just making up objections.
Sorry,
Yes, Your
sir,
Honor.
but can I take this a little bit different direction? It seems we have a fairly limited mandate here, right? The Supreme Court sent this back to the Appellate Division to reconsider in light of Fulton. And we have our old case from 2006 where we passed on this exact exemption. So what in Fulton changes the analysis we did in '06 and the Appellate Division did here?
Sure.
What specifically in
Sure. So two responses, and the first one specifically addresses your question. And that is, in Serio, this court held that the contraceptive mandate wasn't neutral because it didn't target religion as such. In Fulton, as well as in Tandon and other cases, the Supreme Court has clarified that that's only half of the analysis. The other half of the analysis is that a law has to be generally
They didn't overrule
applicable.
Smith, which we all know, right? They didn't overrule Smith in Fulton. So we apply Smith. We can't do anything about that, which we did in Serio, right? So after we get by that, what's changed?
So, Your Honor, two things. The first is what I just said. The Supreme Court has clarified the general applicability analysis, and this court never applied that in Serio. Secondly, the Supreme Court only GVRs a case if there's a reasonable chance that intervening precedent actually undermined its decision. So I think that in and of itself is an indication. But the third point, and I think this is actually the most important one, this court, I understand how the lower courts in New York were bound by Serio. This court isn't bound by Serio except under principles of stare decisis, and Fulton and Tandon have taken the legs out from under Serio respectfully by clarifying it.
Your answer would be that requires us to overrule Serio.
Well, I absolutely think, yes, that it requires you to overrule Serio, and I think that Fulton and Tandon inexorably lead to that result for the two reasons I identified at the outset.
It seems to me from Fulton that the focus now becomes on the exemptions, right?
Yes.
We get by the first part, go to the exemptions. The exemptions in Fulton are very different from those here. So how do you analogize these two?
Sure, in two different ways, Your Honor. The first is the standard that Fulton set out. What Fulton says that once you open the door to some, you can't close that door to others if they undermine the state's interest in a similar way. And that's exactly what we have here, because the Carmelite sisters who are operating the Teresian House nursing home, from the perspective of the state's interest in providing abortion access through insurance plans to women, is no differently situated than the types of religious employers that are covered by the religious employer exemption. So they undermine that interest in a similar way. Secondly, the other separate part of general applicability that is separately, I think, fatal here is the amount of discretion that the decision makers have. That was the specific problem that the holding in Fulton was based on.
I'm sorry, who's the decision maker in that argument?
So in my argument here, the way this process works is that insurers make the first cut subject to the oversight by the Department of Financial Services. And the problem is that when you give decision makers discretion under vague statutory factors, it gives them that authority to pick religious winners and losers.
So DFS is the decision maker.
Ultimately, yes.
And are you arguing that they're applying discretionary criteria? I mean, obviously, whether a company is a nonprofit or a for-profit doesn't seem like a very discretionary decision. So what is it that's
Sure.
the exercise of discretion?
So I'm arguing two things, Your Honor. First, I'm arguing that the face of the exemption itself gives them discretion, and that alone is fatal regardless of whether they actually exercise it. In Fulton, the fatal flaw in Philadelphia's anti-discrimination law was that it had a good cause exception to it that gave them discretion, even though the city of Philadelphia had never once.
But I don't
in the-
see anything like a good cause requirement in this exemption.
Well, I think there's something quite analogous to it. It gives the state the authority to, first of all, assess what the religious tenets are of the employer, the employee, and their customers, their clients. And I don't have any idea how you even make that assessment without running straight into an Our Lady of Guadalupe problem.
I'm sorry, so are you saying under this exemption, the DFS has to engage in some kind of qualitative analysis of what the tenets of the religious
It absolutely
organization are?
has to. That's on the face of the statute. But even if you could somehow surmount answering what I think is an impossible question, they still get to assess what the purpose of the organization is. Is the purpose to inculcate religious beliefs? So suppose I followed the teachings of St. Francis of Assisi, who says, preach the gospel at all times and use words only if necessary. That's what the Carmelite sisters do at the Teresian House Nursing Home. They provide services, nursing home services, to the indigent elderly as an act of faith. The state has the discretion to determine whether that's good enough. Is their purpose providing nursing home services, or is their purpose the inculcation of religious values? They seem to suggest that it's the former, because the DFS guidance specifically says that religious nursing homes aren't covered. But this is the type of discretionary decision that this statute gives to the state, and that's the type of discretion that totally undermines the
So if there
constitutionality
were
of this
no
law.
exemptions for religious employers, would this regulation be constitutional?
Your Honor, if there were no exemptions for religious employers, I'd be making a different set of arguments. But I would probably still be arguing that it's unconstitutional. I'd be relying more on the secular exemptions, and I'd also be more arguing that Smith should be overturned, which I understand that Your Honors don't have the authority to do. But here, I do have the religious employer
That would be a
exemption.
law of pure general applicability if there were no exemptions at all, right?
Oh, sure. If a law has absolutely no exemptions at all, that is a law of general applicability. That is not
Here,
this
you're
law.
Are you arguing that the exemptions don't go far enough? They don't include enough people?
Yes, Your Honor. Yeah, I think that is the gist of my argument, and that's essentially what the Supreme Court has said.
I thought you were arguing something perhaps more fundamental. As long as DFS gets to choose who gets the exemption, that's, at the end of the day, the problem. If, as you say before, they had instead chosen what you're describing as the federal approach, to say, you all choose if you should be exempt, and we will honor that. I would take it you think that that doesn't run
Yeah.
afoul of anything the Supreme Court has yet said and would be constitutional. It's that DFS is going to ultimately make this decision.
To be clear, Your Honor, and I want to be clear on this, I'm saying two different but related things, because general applicability under Fulton and Tandon have two separate prongs. And both of them, the failure to satisfy either one means a law is not generally applicable. Prong one is, does the law exempt some but not others, even though they undermine the state's interest in a similar way? I can give you an example. Suppose you have a statute that says religious nursing homes are exempt religious employers as long as they serve only people of one religion. But religious nursing homes are not exempt religious employers if they serve people of multiple religions. Wholly apart from discretion, that wouldn't be generally applicable because it has an exemption for some, but not for others, even though they equally undermine the state's interest. Separate and wholly apart from that, an exemption is not generally applicable if it gives the state too much discretion to pick religious winners and losers. And I'd point you to the Second Circuit's decision in the Kane against de Blasio case as an example of that. That was a case that involved New York City's COVID mandate for public school teachers. And the Second Circuit did two things. First, it held that the mandate on its face was generally applicable because on its face, the mandate didn't have any religious exemption at all, and the exemptions that it did have weren't inconsistent with its larger interests. Put that to the side. The second holding is the more important one. There they addressed the constitutionality of a religious-only accommodation that was imposed in arbitration proceedings. And what the court said was that that religion-only accommodation undermined the general applicability of the law. It had a couple of problems with it. One was the religion-only accommodation gave decision makers a large amount of discretion to pick winners and losers. That was the second part of the Fulton analysis. I would say that another problem with that is it was dramatically under-inclusive. It only applied if you, for example, had a letter from a religious official in your church attesting to your religious beliefs. I think we've got both of those problems here as well.
And I just want to understand your first prong properly. When you say some but not others, do you mean some religious entities but not others, or do you mean some employers but not others?
Well, Your Honor, only, of course, somebody with a religious exercise claim can bring an argument under the Free Exercise Clause. So by definition, the person bringing that claim is going to have a religious reason for it. But what you do is you look at the exemptions that are on the books, whether they're religious or non-religious, and then you look at the plaintiff in the case who by definition is religious, and you ask, does that objection on the books undermine the state's interest in a way similar to extending it to the religious objector?
So that I understand you, make sure I understand you. So if the state had very cleanly given a exemption to anybody you claim is a religious employer, but had not given an exemption to IBM, let's say, that would be a theoretical problem, but there would be no plaintiff to bring the case.
Well, Your Honor, I'm not sure I even understand the distinction. It's neither a theoretical problem nor is there a plaintiff because
Well,
there's no
the state's interest would be undermined, right? The state's interest would be undermined in your words because they're not, the exemption doesn't serve the purpose because now some people are getting this protection and some aren't.
So arguably, the exemption would make the statute not generally applicable, but you wouldn't have anybody that could
Wouldn't have a
complain
plaintiff,
about it.
right.
So again, it doesn't seem to me to at all be an issue. But I think that my main point, though, is that here you actually do have religious objectors that undermine the state's interest in a similar way, which means the state does have to satisfy strict scrutiny. And so my last point is they haven't even attempted to satisfy it in the now 6 odd years of the litigation of this case.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Laura Ettlinger for the Respondent Superintendent. Fulton does not require this Court to overturn its precedent in Catholic Charities and the conclusion in Catholic Charities that a law is neutral and generally applicable when it contains a limited accommodation. And the Court should not overturn it because here the regulatory scheme does not involve a mechanism for individualized exemptions, and it does not treat comparable secular conduct more favorably. And before I turn...
So then how does DFS figure out the second part? The entity primarily employs persons who share the religious tenets of the entity.
Well, what we know from the history and the enforcement history of the parallel definition in the contraceptive coverage requirement is that this is a self-certification process, and there is no history that any such questions are asked of an organization when it self-certifies. And in fact, the very guidance document that plaintiffs point to in their reply brief contains additional language that plaintiffs did not quote that make it clear that there is deference to the requesting objector.
What if they can't answer number 3 because they don't ask anyone's religious affiliation?
Of their, the people
Whoever
that,
they serve.
that they serve.
Yes, number 3 says, the entity serves primarily persons who share the religious tenets of the entity. What if they don't ask? They feel that that's not appropriate.
Well,
Because
if,
they serve anyone.
well, if they feel that they serve anyone, I think they would feel they couldn't certify that because their primary, the primary people that they serve would not necessarily
They can't
be of their
certify it because
faith.
they don't know. It may very well be that they're doing that, but they don't know.
Well, I just want to step back for a second, if I may.
Well, all I'm saying is, before you step back, you can step forward. How would DFS deal with that situation? An employer that says, it may be that I can satisfy number 3, but I don't know because I don't ask this question.
Well, I
So
don't.
that doesn't mean they don't fit in it. What does DFS do in those situations?
Well, first of all, it's not DFS in
The
the
insurer,
first
excuse me.
instance. It's the insurer. I think we don't have that history to know, but it would seem reasonable if an insurer was faced with a certification that certified it met all the other criteria, including the pretty narrow definition under the IRS provision, because that's not just non-for-profit, that's special religious non-for-profits who don't file tax returns in the first place, and a requester certified that they primarily serve individuals within their faith because they mean to. I don't think there would ever be a
No one goes
question.
behind the self-declaration, is that?
Well,
I
to
just
the-
want to be clear about that.
Well, what we know is that when DFS was concerned about the certifications, it was when insurance companies were simply ignoring the criteria, and they were issuing exempt policies to what on their face were for-profit businesses, a cafe and a doctor's office. That's what we know has been the problem that arises.
But what would DFS be authorized to do in a situation where there was an exemption innocently but incorrectly submitted? Do you have some remedial power or?
Well, the DFS has enforcement power over the insurance companies. So if it became aware through an audit or something that the insurance companies were providing exempt policies to organizations that did not seem to fit, the DFS could take enforcement action against the insurance company. And I don't know exactly
Not
what
against
that-
the employer?
Not against the employer,
Counsel, let me
no.
ask you a little bit differently this issue. So let's say you have one of these entities, and they know they are not primarily serving people who have this, so they can't apply. So aren't they faced with the very choice the Supreme Court talks about in Fulton between curtailing their activities, meaning we're not going to serve a broader population, or doing something they don't, or compliant, right? So that's the language of Fulton, which gets you into the problem in the first place. Curtail its mission or proving, in this case, relationships inconsistent with its beliefs, they have to either curtail their mission and not serve a more general population, or provide this type of coverage. And isn't that the very choice Fulton talks about?
Well, that is the choice that is identified as a burden in Fulton.
So your exemption is in placing the same burden on them. That's the original problem.
Well, even if it were, the question still, Fulton goes on to ask the question whether what we have here is neutral and generally applicable. And with respect to general applicability, because if you don't, even if you have a burden, Smith says, if it's general and neutral, it can be applied. And so the question is whether it's generally applicable. That's the emphasis of Fulton. And this is not an individualized, a mechanism for individualized exemption. This question about how the criteria are applied is not the question you ask when you're determining whether something is an individualized exemption. An individualized exemption is one like good cause, like sole discretion, that allows the decision maker to make value judgments about the motivations of the party seeking an exemption. So I look at your particular circumstances and your motivations, and I say, okay, I think that's good cause. And I look at somebody else, and they have different circumstances or different motivations, and that's just not what we have
But
here.
isn't at least 3 of these, forget number 4 for 1 minute, the internal revenue, isn't that already doing the work that you're describing?
No, for
Why
two
not? Why
reasons.
not?
First of all, because there is just a distinction between a accommodation that uses criteria that can be objective and are standardized from an individualized exemption, which means it's just the exercise of discretion. You fit in or you don't fit in because somebody says so. Here, you fit in if you meet those criteria,
I mean,
I-
regardless of the substance of the criteria, as long as you have, as I was asking your adversary before, some boundaries in which you must exercise that discretion, that's what's
That's
different?
what Fulton was getting at, and there's a reason.
That has to be, it's just my choice. I can decide for whatever reason I want whether or not to exempt you.
Yeah, that's an individualized exemption. There are two circumstances for lacking general applicability, but that is the one. That was the one in Fulton, and that was this concern, because if there are no criteria, you're inviting the decision maker, and this is what Fulton says, to find that some circumstances are more favorable to the decision maker than other circumstances. It invites treating, in Fulton, religious motivations less favorably than secular
So
motivations.
I take it your position would be that this would run afoul of Fulton if you had these criteria, and it also said, but the commissioner, DFS, can nevertheless grant an exemption even if it does not satisfy these other criteria.
Exactly. That part of it, that would be the individualized exemption problem in Fulton.
But the underlying principle is that even if some burden is imposed, that's constitutionally tolerable as long as the burden is objective and uniformly, where the criteria that make up the burden are objective and uniformly applied?
Well, two things. The overarching principle of Smith is not about religious accommodations. So we have something different here than what has been looked at in any of the cases. And there is a principled distinction between regulatory requirements and religious accommodations for purposes of general applicability. And that's because a religious accommodation, which by its terms means it's not been constitutionally required, is a situation in which the state has elected to serve another compelling interest, its interest in promoting free exercise, along with a competing compelling interest, its regulatory interest here, ensuring access to critical reproductive health services.
That prong primarily serves a population. How does that relate to the religious exemption at all? In terms of, what's the purpose, what's the work that prong is doing there? In terms of determining whether should be a religious exemption? Like, what's the relationship between who you serve and what your beliefs are?
The answer to that question is there doesn't have to be that kind of direct connection between the limit that the legislature drew, the line drawing that the legislature chose for its accommodation that it's offering.
Then why aren't you burdening them with something that's not relevant at all to what you're trying to get at?
Well,
Because it is a burden to say you can't serve this population if your mission is to do some charitable
Well, the
work.
question would be, has the legislature, in balancing these two competing interests, because that's what makes it very different from a requirement that religious and non-religious organizations have to adhere to. Here we have a requirement that applies to everybody, but then an accommodation for a different purpose, not to ensure access to critical health care. In fact, the accommodation undermines the state's interest in ensuring access to critical health care. So the state is balancing these two interests, and the question is, has the state drawn a reasonable line?
And what's the reasonable purpose of that prong of the test?
The reasonable, it's not the particular prong, it's the line drawing that was drawn, and essentially criteria, as the court explained in Catholic Charities, that were defining houses of worship and the like versus charitable organizations that work in the community. And the legislature chose the line here, or initially the superintendent chose the line here for a number of reasons, but first because this was simply traditionally the religious accommodation that was provided for contraceptive coverage requirements. It had been the standard in New York for nearly 2 decades. It had been workable insurance companies were able to readily identify who could receive an exempt policy. In fact, it was in use in the many states.
So even if-
So since an employer cannot discriminate on the basis of religion, I'm not sure how you get away with that number 3. I'm not understanding that at all.
Well, in my understanding,
To comply, one would have to say, regardless of how the merits of the applicant for a job, will not hire them unless.
well, my
Because
understanding.
it furthers, because you're saying, your line in the sand, or DFS line in the sand, if I'm getting this right, is that you wanted to preserve houses of worship, but not charitable institutions who are in a business environment.
That was the general principle. And my understanding is religious organizations do have some authority under the human rights law to use religion as a basis
Yes, but this
for
is what I'm
hiring
saying, that begs the
principals.
question whether or not they're the kind of religious organization that should get the exemption. That's the whole point. That's the point of my question.
Well, but the question is, did the state draw a reasonable line?
Well,
But
I
it's not-
understand the employee, I'm not talking about, yes, I had the question about the employee, but what about number 3, those who serve? I mean, that is very typically within sort of you think of some of the religious missions, it is to serve whoever is in need,
Right.
regardless of whether or not they happen to share your religious tenets.
Yes, and that's an effect of the criteria. So it's true.
But why doesn't that undermine the exercise of their religion? That's that choice, perhaps, that Judge Garcia was referring to.
I'm sorry,
Got to-
why
I've got
does
to forego this part of my religious mission.
Why doesn't it
Number 3, yes.
undermine what? I'm sorry, I missed the undermine what.
That
mission of the
this
organization.
particular prong and this, what you're calling discretion, non-discretion, somehow does not run afoul of Fulton when it is, as I think Judge Garcia was saying before, presents the catch-22 that Fulton is indeed saying is not permissible.
Because that aspect of Fulton is talking about whether there's a burden or not. But you don't go beyond burden if what you have is neutral and generally applicable. And we have a scheme here that's neutral and generally applicable, and we have a religious accommodation that the state decided ultimately would best serve its regulatory interest while also serving its other interests by drawing the line here.
But it does seem unusual that you could solve your issue with creating a burden by curtailing the mission or complying by an exception that forces you to curtail your mission, right? That seems an unusual solution to the problem.
Well, to the problem of balancing these
To the
twin
problem of an undue
interests?
burden. You have an undue burden, and I agree, that's what Fulton says in the beginning. We look at, is there an undue burden? They say, you're putting this organization to the choice of curtailing its mission or approving relationships inconsistent with its beliefs. That's Fulton. And they go on then to say, okay, how do we look at this now? Is it neutral or general? And you're saying we can solve that initial problem by imposing an exemption that curtails, that forces them to curtail their mission or not get the exemption.
Well, two things. First, it's because it's a religious accommodation. So Fulton, everything Fulton said is not directly applicable to a religious accommodation. So plaintiffs are asking the court to take what Fulton says, and in an unprecedented way that has not been accepted by any court, no court has so held, to map it onto an accommodation. And this court said in Catholic Charities, that's very problematic, because if you do that, if you subject a religious accommodation that's not constitutionally required to this higher scrutiny, you're going to discourage the state from providing accommodations. And the end result will be that you have restrictions on free exercise rather than promoting free exercise. So it's the purpose of it just doesn't map on to a religious
Well,
accommodation.
Sergio, of course, said the same, that if you really follow the plaintiffs there all the way through, that means that you would end up with the question you had before. Why not just get rid of all the exemptions?
Well, you could.
I think your adversary is suggesting that might create another constitutional problem, which is for another day. This is
And we
not
don't
this
have
case.
that here. And that was exactly what the court was concerned about in Catholic Charities. If that definition, which is the exact same definition here, were looked at in some way where more was required than a rational basis, the government would be discouraged from providing accommodations, or so limited in the accommodations it could apply. Maybe it can only apply if the rule were it can only offer an accommodation when it encompasses all religious objectors.
So to the extent that some of the questions you've been asked might indicate that the court is questioning whether there's even a rational basis with respect to that third prong, would part of your argument be that we're just simply bound by stare decisis from Catholic Charities with respect to that?
No, for a couple of reasons. The accommodation, there are some factual differences between Catholic Charities and the facts of this case. So they don't go to the court's conclusion that it was generally applicable and neutral and thus subject to rational basis review. The differences are that involved contraceptive care, and this involves abortion services. But that's not a meaningful distinction, because we know it's not the government's place to question how important a religious belief is to the religious objector. So they're treated all the same. And the other distinction, factually, is just the mechanism that is used for how the accommodation operates. So in Catholic Charities, the contraceptive coverage operated so that when it was an exempt policy was issued, the individual employee was given the option of purchasing a rider and had to pay for it. And in this case, the coverage by a rider is automatic and at no cost. So those are the distinctions.
They thought your red light is on, but just to clarify something that was said before, is it your representation now that nursing homes are able to get this exemption, these kinds of nursing homes? There's no barrier to them, if they can answer these questions, of course.
I think what you're asking, I mean, in general.
Some reference to the website, that's what I'm trying to get to.
Well, the guidance document does say, based on Catholic Charities,
Okay.
that the plaintiff, one of the plaintiffs in Catholic Charities, was a nursing home, and there was an assumption that the plaintiffs there, based on concessions, did not meet the criteria. So the guidance is using that historical precedent. But I think what you're really asking, or you may be asking, or what I would like to answer is,
Perhaps the last, yes.
could there be situations on the very outer edges
Okay.
that raise difficult questions? And if there are, the answer is, this is not the case that presents that issue. Plaintiffs have never sought an exemption. And we know from its long history of use and the guidance documents that say, look at the name, and if you're not sure by the name, look at documents or representations, that there's deference. There's no reason for plaintiffs to fear that if they do request an exempt policy, they'll be subject to any such questions.
Thank you.
Your Honors, three quick points, and of course, happy to answer any other questions you have. The first is the guidance document. We printed this off of the website. As far as I can tell, they haven't pulled it down. They haven't indicated that it's archived and no longer applicable. This is the operative guidance document on the religious employer exemption. Specifically says religious schools and religious nursing homes not covered. It then says, and this goes to the self-certification point, and I'm quoting, "An issuer that receives a request for exemption may not rely solely on a self-attestation from an employer." Full stop, period. So I think it's quite clear that this is not a self-certification regime. And Your Honor, while this isn't in the record because it only arose in 2019, I would point out that in 2019, the Sisters of St. Joseph, which is a religious order of nuns based here in the Albany area, was denied a religious employer exemption for the insurance plan that covers the roughly 300 nuns and the roughly 100 staff members that work for them because they hadn't put forward enough documentation to show that they were only serving people of the same religion and that their purpose was the inculcation of religious values. That brings me to my second point. And I know there was a lot of discussion about the prong about whether you serve people of the same religion. I'd also like to focus on the prong about whether you employ people of the same religion. That is a prong that is impossible to apply without running straight into a problem under the Supreme Court's decision in Our Lady of Guadalupe, which made clear that it is impossible for the state or a court to determine whether somebody shares the same religion as another. Take it in the context of this case. Does a pro-choice Catholic and a pro-life Catholic, do those two people share the same religious tenets? I have no idea how to even begin to answer that question, and I certainly know that Our Lady of Guadalupe tells us that that's not an answer, a question that should be answered by any governmental authority. And this is my final point, Your Honor, and it goes to the prong that we were talking about, whether or not you primarily serve people of the same religious beliefs. Under this law, the state would have the discretion to deny a religious employer exemption to Mother Teresa and the Sisters of Calcutta, because the last time I checked, the poor people of Calcutta were not predominantly Catholic. This is a regime that is contrary to the Supreme Court's precedent from root to branch. This court should make clear that its decision in Serio is no longer good law and reverse the decision below.
Well, it sounds like you can't even have, although you said at the beginning, I thought you said initially that if it was truly self-certification, no one looks behind the curtain, that would be fine. But it sounds like from what you just said, one could not certify to number two because of the very difficult and challenging
I
issues.
think
And
that's-
perhaps, as I suggested, to number three, because you'd have
yeah.
to ask.
And I think that's right, Your Honor. But again, I want to clarify the two strands of general applicability. One of them goes to discretion, and maybe the self-certification piece could be relevant to discretion. Put discretion out the window. Let's assume that this was a regime with zero discretion at all. It still fails under the first part of the Fulton analysis, which says that anytime you have an exemption, even a completely categorical, no discretion exemption, anytime you have an exemption that undermines your interests in a similar way relative to the people who are outside of the exemption, that's a separate problem. Remember in the Tandon case, those were the COVID cases, where you had an exemption for, for example, movie theaters, but not for churches. There was no discretion at all in that regime. It was pretty clear what a movie theater was and what a church was. But the court held in those cases that separately undermined the general applicability of the law. Here, we just happen to have both of the problems in this regime.
Counsel, one question with Chief's permission. You went through a number of cases in the Supreme Court, arc of the decisions there. Before Fulton, do you think our Serio decision was constitutional?
Your Honor, I do think Serio was wrongly decided the day
Why?
it was decided because I don't think it was neutral. I don't think this law is a neutral law. I think that when you have factors that require you to assess the religious tenets of an organization, its employer, and the people that it serves, and require you to assess whether the purpose is the inculcation of religious values or providing services to the poor. I can tell you from my client's perspective, no difference between the two. I don't think that that's a neutral law, but I think that Fulton
And let me ask the follow-up then. Yes, I think
Yeah.
you're going to get there. So we disagreed with that. So
Of
how
course,
does
yeah.
Fulton change that analysis? How does it add to what you just said?
because in Serio, the court didn't have the benefit of the court's explication of general applicability. Remember, Smith says that a law has to be both neutral and generally applicable. Prior to Fulton, it wasn't quite clear if that was a unitary test or two separate prongs. And in Serio, this court understood it to be a unitary test that required religious targeting as such. In Fulton, the court was presented with a religious targeting argument. And what the court said is, we don't have to address the religious targeting argument because that's part of the neutrality analysis. We're going to do it on a completely different basis, the general applicability half of the prong, which doesn't have anything to do with religious targeting, but rather has to do with whether you have exemptions that undermine your interest or give the decision makers too much discretion. And those two things weren't clear before Fulton and Tandon. This court didn't address either of them in Fulton and Tandon. The Supreme Court GVR'd in light of Fulton and Tandon, specifically to address that second half of the analysis that it had since clarified.
And so if only the fourth factor were in the statute, not the first three, does that survive?
Your Honor, I would no, because I would still say that you've got an exemption that undermines the interest. And I'd also point out that fourth factor is completely irrational. What the fourth factor says is that, look, all, or most religious organizations are tax exempt, including all of my clients. All the fourth factor is, it's a tax law that says some types of tax-exempt organizations have to, at the end of the year, file a piece of paper with the IRS that says, I'm in fact a tax-exempt organization. Other types of tax-exempt organizations don't have to file that piece of paper. That has absolutely nothing to do with the state's interest here. So I'd be arguing that that failed rational basis. But wholly apart from that, it still constitutes an exemption that undermines the state's interest in a similar way relative to extending that exemption to my
But
clients.
shouldn't we be looking at health insurance policies for general applicability? Those that are issued to secular employers and those that are issued to religious employers, and why aren't they comparable?
Your Honor, I'm not sure I'm following
Like, are
the
there any
question.
circumstances that permit a secular employer to opt out of providing coverage that a religious employer would be denied that exemption? Like, in other words, this regulation is being applied to both secular employers and religious employers in the same exact manner. So where's the constitutional infirmity?
Yeah, I think the constitutional infirmity is that, well, look, if you had a set of insurance plans that covered everybody the same with zero exemptions for anybody, that would be general and neutrally applicable. And we'd have maybe different problems. We wouldn't have the problem that I'm talking about here. If you had an insurance regime that created exemptions for secular employers but not religious employers, well, I think that's effectively the Supreme Court's decision in Fulton. And that's where you have the type of problem that you have here. Likewise, if you have exemption for some religious employers but not other religious employers, even though they undermine the state's interest in a similar way, you have the same problem as you have here and in the Fulton case. I'm not sure I answered your question, Your Honor.
I'm not sure either.
Yeah.
I'm just saying that the regulation is applied the same way, whether you're a secular employer or whether you're a non-secular.
But it's not, Your Honor. There's a religious employer exemption that applies to some religious employers but not to other religious employers. And so that gives rise to the first part of the general applicability problem. And in addition, it's a regulation that's got such vague and nebulous terms that it gives the decision makers the discretion to pick winners and losers, much as the exemption that was at issue in the second part of the Kane against de Blasio decision out of the Second Circuit, which I would submit has factors that are at least as objective as the one at issue here, and probably much more objective than the ones at issue here.
Thank you.
Thank you, Your Honor.